Good morning. This is Sarah with the California MBA. Thank you so much for joining us. I want to thank you for coming on for our webinar for the Mortgage Quality and Compliance hosted by the California Mortgage Bankers Association. We are excited to have our sponsors, the compliance group, also join us today. And if you'd go ahead and introduce yourself and tell us a little bit about you.
Hi, this is Jim McCracken, this National Sales Manager from the Compliance Group. Sarah, thank you very much for the opportunity to speak today, and welcome everyone, and thank you for joining us. We are a national provider of origination QC, servicing QC, and compliance solution audits, such as California Per Diem, Internal Audit, AML, to name a few. The Compliance Group has one primary goal: keep our clients safe. So our team consists of highly knowledgeable, meticulous, thorough, and passionate and fun individuals, and we hire and retain only the best. We engage in such a way that we become a critical component within our clients' businesses. Our clients tell us that our process, our staff, our quality, and how we communicate instills confidence and certainty that their business is well protected. The bottom line is we want our clients relaxed so they can focus on what they do best. Here's a recent email from a QC client. I can't tell you how happy myself and my staff are to be working with such an attentive group of people. This type of comment from clients is common. If you are a client of the Compliance Group, thank you for your business and trust. If you are not a client but would like to find out why our clients are so happy, please contact me. Sarah, back to you.
Thank you so much, Jim. I have the agenda up, and Monica, if you'd like to share the agenda with everyone.
Sure, thanks so much, and welcome everyone to our Mortgage Quality and Compliance webinar today. We are going to start off with a legislative update from the CMBA's legislative advocate, Pat Zenzala. Then we're going to hear a legal update from our MBA General Counsel, Michael Pfeiffer. Then we're going to move on to our main presentation about internal audit function in your CMS. And I will be doing introductions of our speakers at that time. And that is our agenda. We may have an opportunity for questions at the end, time permitting. Back to you, Sarah.
Thank you.
Perfect. Would you like me to start, Sarah?
Yes.
So, hello, my name is Pat Zenzala. I'm the California MBA's lobbyist in Sacramento, and I'm going to cover a few, I think, issues of interest to the industry. First, kind of a level set as to where things are at. The California legislature adjourned on September 13th, so they're pretty much done for the year, and Governor Newsom has until October 13th to sign or vetoes any bills that were passed by the legislature in the final few weeks of session. So his office is very busy at the moment reviewing all of the bills and support and opposition, et cetera. The first thing I want to talk about is Bill AB 1355, which deals with a topic that is of great interest to the industry, and that's the California Consumer Protection Act or Privacy Protection Act. Dealing with how personal information of consumers can be used or not used, depending on the customer's or consumer's choice. Several bills were introduced in an effort this year to improve and clarify the Act, and AB 1355 is one of those bills that actually passed and is on the governor's desk. It deals with several important issues. First is that it exempts de-identified or aggregate consumer information from the definition of personal information. That's a helpful change. And then the bill creates a one-year exemption that would expire January 1st, 2021 for specified business-to-business communications or transactions. That's another key change that business sought in the Act, so that you're only dealing with business to consumer transactions and flow of information versus business to business transactions and flow of information. You may ask why only the 1-year time frame, and the answer is because it was a compromise with labor groups that came in the process very late and threatened to oppose an attempt to kill this bill and another bill, unless we worked with them basically, and the 1-year sunset was a compromise. So we would continue to work with them on issues of concern for them in CCPA, and hopefully next year we'll be able to extend this exemption, hopefully indefinitely. The other important things that 1355 would do is it clarifies the Fair Credit Reporting Act under CCPA as far as the exemption of information that's covered by FCRA. It specifies that businesses do not need to collect personal information that they would not normally collect in order to essentially comply with the Act, or keep that information for longer periods than they would otherwise in order to comply with the Act. And then it also provides rulemaking authority for the Attorney General in dealing with businesses as far as complying with the verifiable consumer requests, or how a business determines what's a verifiable consumer request. The next bill I want to mention that passed this year is AB 25, and this bill deals with the employee exemption issue. One of the problems with CCPA is the definition of consumer could be read to include the employer-employer relationship. And so AB 25 exempts from CCPA personal information collected by a business in certain employment-related situations, once again for 1 year, so until January 1st, 2021. It changes CCPA so that the law does not cover the collection of personal information for job applicants, for employees, for business owners, for directors, officers, medical staff, or contractors, as long as that information is only used in the context of the person's role as an employee. So that's a helpful change, and once again, hopefully next year we'll be able to extend it out indefinitely and not have the 1-year sunset. And then the final issue I want to mention is the passage of AB 1482. Very simply, this bill creates a rent cap under California law. So in any 12-month period, a property owner can increase the rent up to 5% plus the percentage change in the cost of living, or 10%, whichever is lower. And so that's a significant change in California. There are some exemptions under this new requirement. One of the primary ones is for new construction. So housing that's been issued a certificate of occupancy within the previous 15 years would be exempt. Also, single-family homes, condos. So housing that is alienable, separate from the title. So once again, single-family homes and condominiums would be exempt as long as they're not owned by a real estate investment trust, a corporation, or a limited liability corporation. Those, I think, there was a great deal of opposition from the commercial side, especially of the mortgage industry, to this act, but because of the problems with housing in California and the cost and the lack of availability of affordable housing and the very high rents, finally had momentum for this to pass, and we do expect the governor to sign this. That's it as far as issues that I wanted to highlight today on the call.
Michael, did you have anything to add? It doesn't appear that we have slides.
I had my slides a little while ago.
They're attached to Pam's presentation in the front.
Oh, okay. Just one moment while I switch the other one to the other slide deck. I do apologize.
No. Great. And so then, Michael, if you can then take it away and give us your litigation update, that would be appreciated.
Great. I should be able to do this fairly quickly. Thank you, Monica. I want to just talk briefly about the ongoing litigation involving the constitutionality of the Consumer Financial Protection Bureau. Obviously, the statutory validity and the powers of that bureau are critical to our business and to everybody on this call. And as many of you are aware, there's several pieces of litigation that are pending under which the constitutionality of the CFPB is being questioned. One of the ones that is of greatest note, I think, is involving a case that is in the Ninth Circuit. This is a decision that came out last May. And I'm just kind of it's like we're kind of like an iceberg here. I'm just going to lay this as a foundation for really talking about the broader kind of issues that are going on and what's going on in some of the other courts. But the one we're watching is this case called Sela Law LLC versus CFPB. And in that case, some of you are familiar with that. The CFPB filed a petition to enforce a civil investigative demand that it issued as part of its investigation into whether the law firm had violated the telemarketing sales rule. And the district court for the Central District of California granted the petition for the in connection with the demand to enforce the demand, and then ordered the law firm to comply with the civil investigative demand. There was one uncontested modification. The law firm appealed to the Ninth Circuit, contesting the constitutionality of the CFPB, basically saying that the structure violates the separation of powers provision of the Constitution because it allows the director to be fired only for cause, which is defined as inefficiency, neglect of duty, or malfeasance in office. In that decision, the Ninth Circuit said, no, it is constitutional. The structure of the CFPB, headed by a single director, can only be removed from cause. That's just fine. The civil investigative demand didn't violate the practice of law exclusion, and it did not violate provisions of Dodd-Frank requiring the CIDs to state the nature of the conduct constituting the violation. So the Sela law firm petitioned for certiorari, which is basically a request for review by the U.S. Supreme Court, and that case has the court hasn't decided yet whether it's going to take it up for review. The procedure is that they docket it while it's called, certiorari or cert is pending. They docketed it, and it's going to be considered probably at their October 11th conference, and they'll decide at that point in time or shortly thereafter whether or not the court will accept the case for review. Meanwhile, next slide, please. There's been a couple of briefs that were filed and some political changes at the CFPB. The CFPB and the Department of Justice filed a brief with the court in support of the petition for certiorari by the Sela law firm, noting, basically reversing in the Ninth Circuit opinion, the CFPB said, no, we want to have the CID valid, and we're opposing this notion of constitutionality. Now, the CFPB and the Department of Justice are saying, we've changed our minds. We think that the constitutional structure of the CFPB is faulty, is defective. It's not constitutional, and we want the court to declare it unconstitutional, take the case up and declare it unconstitutional. They're basically, the position that they're taking is that the for-cause removal provision infringes upon the separation of powers, which they say is fundamental to our constitutional structure. And of course it is. But they're saying that the proper remedy is for this violation is for the court to sever the provision providing for for-cause removal, and then also leaving all the rest of the provisions remaining. And what they're saying is that this creates uncertainty that undermines the Bureau's ability to fulfill its mission. That was filed on September 17th. On the same day, the director of the CFPB, Kathy Kraninger, sent letters to Majority Leader Mitch McConnell and Nancy Pelosi explaining the reasons for the change. And I've listed those on the next slide, please. There we go. Basically, they're saying this. In those letters, they're basically Director Kraninger is basically saying that the for-cause removal provision does interfere with the president's executive authority, and that because the Bureau is an agency of the executive, which that issue in and of itself, by the way, has been somewhat of a dispute over the years as to whether or not it's an executive agency or it's an independent agency. But she takes the position it's an agency of the executive branch. She's decided that they should adopt the view that the for-cause removal provision is unconstitutional, and directed and this is the key part. She said in these letters, I've directed the Bureau's attorneys to refrain from defending this provision in cases pending at the district court and court of appeals levels. So, the CFPB is not defending challenges to its constitutionality, and that creates an interesting situation for the court. It's sort of, they're trying to force the court to make this decision. Pretty clever kind of move. I'm not sure the Supreme Court's going to appreciate them doing that, creating this uncertainty by taking that position, but that's the position that they're taking. And as you can imagine, we in the defense bar, in light of the fact that CFPB is not going to defend its constitutionality, guess what we're going to argue in any one of these defense cases? And that's one of the reasons that it's going to create this uncertainty, because people are going to argue that it's unconstitutional now, and the CFPB is not going to defend that. And so the effects of all of this are kind of crazy. We've got this decision, the Sela Law decision in the Ninth Circuit. There's also another decision in the D.C. Circuit that basically says that the for-cause provision doesn't violate the separation of powers doctrine. But the Fifth Circuit recently held earlier this month in a nearly identical structure that the Federal Housing Finance Agency is unconstitutional because it has a similar provision in it. So in effect, the circuits are kind of split on this, which is a classic situation in which the Supreme Court tends to get involved. Meanwhile, the consequences of this are just creating all kinds of craziness. Obviously, as I said, if you're a lawyer representing a business that has received a subpoena or an investigative demand from the CFPB, you're going to argue that the agency's unconstitutionally appointed director can't oversee the investigation. If you represent someone, a defendant in enforcement action, for similar reasons, you're going to argue that the director can't order a resolution because she was appointed improperly. In fact, I suppose somebody could even argue that the director can't instruct the CFPB to not defend its constitutionality because she's stopped to do that because she doesn't have constitutional authority to do that. Anyway, just kind of crazy things are going on. And then there's a question of what happens if the CFPB, to the CFPB's work if the Supreme Court determines that the appointment provision is unconstitutional. It's not clear that certain of the justices will reach that conclusion. Justice Kavanaugh, in his earlier holding in the D.C. Circuit, basically said that it could be severed. It's funny. He's one of the ones at the D.C. Circuit that said, yeah, it's unconstitutional, but this clause can be severed. It's not sure. First of all, it's not clear that everybody's going to agree with him. Second of all, it's not clear what they're going to do if they do find it unconstitutional. And will it agree that the proper remedy is just to fix the provision, or will it strike down the entire CFPB as an entity? It's just not clear. And a lot of people, including the litigants in the Fifth Circuit, have argued, and the Second Circuit have argued, those are still currently pending cases, have argued that the whole bureau should be struck down. One of those cases in the Second Circuit, at the district court level, the judge Loretta Preska basically said that the severability clauses don't permit courts to rewrite the statutes, and that if this appointments clause is invalid, the whole statute falls down. So there's also people at the Justice Department and the CFPB who will say, well, you don't have to go that far. If the severability provision, is fixed, then we can sort of retroactively ratify everything that the Bureau has done, cutting off any additional challenges. And that there'll be litigation over that. So I bring this to your attention to let you know that what's going on right now with the CFPB is just crazy, and it's totally unclear what's going to happen. If the Supreme Court doesn't take this up, then it's going to be continued to be uncertainty until they resolve it. So that's kind of my report, and we're going to be watching it obviously like a hawk. We're going to see what they do in October, whether they'll actually take it on, or the Supreme Court takes it on. If they do, then they'll probably stay all the other actions, or they might even bring those into their ambit and decide those as well. That's my report.
Great. Thank you so much, Michael. Now we're going to move to our featured presentation on internal audit. And we're going to have two different portions. First, Pam Fleckser is going to present, and then David Heltman is going to present. So I would like to just briefly introduce them to you. Pam Fleckser has been in the mortgage industry for over 25 years with experience in all aspects of loan manufacturing with a focus on compliance, internal audit, fraud detection, and quality control. She's developed and managed the QC and internal audit departments for several mortgage companies, where she also was the main contact for the external audits, including the agencies, DBO, and CFPB. She's currently the Director of Internal Audit and Risk Management for Paramount Equity Mortgage that does business as LoanPal. In this role, she manages the internal audit program, fraud and risk management areas, and is the chair of the fraud committee. She's been a member of the Association of Certified Fraud Examiners and the creator of Insight Beyond the 1003, a comprehensive QC plan. She's a member of the Mortgage Quality Assurance and Compliance Committee with CMBA and has been a presenter for us in the past and at our various conferences. She's also a member of the Institute of Internal Audit. She attended Santa Rosa Junior College and numerous trainings through Fannie Mae, Freddie Mac, the American Bankers Association, and various industry groups over the years. We're pleased to have Pam back as a speaker. After Pam's presentation, David Heltman is going to give us some additional information on the topic. David currently serves as an operational compliance and informational system auditor for Plaza Home Mortgage for the corporate and branch location since November of 2017. There, David is responsible for administering an internal audit based on addressing and evaluating risks for new, renovation, or reverse mortgages by ensuring all state and federal guidelines are followed. Prior to joining the audit team at Plaza, David had over 8 years' experience as a loss manager for mortgage servicers with a primary focus on reviewing and evaluating foreclosure alternatives for borrowers. In addition to being a member and speaker for CMBA, David is also a member of the Institute of Internal Auditors. David holds a BS in Criminal Justice Administration from San Diego State University. And David also shares that he is married to his wife, Jennifer, for over 5 years, and they have 3 Chihuahuas that keep them busy, just so you don't think all he does is focus on internal audit. And with that, I'm going to turn it over to Pam.
Hi, thank you so much. I appreciate the introduction. I just want to make sure that I am seeing the slides. I'm not seeing them on my end, so I'm concerned here. It's asking me to show my screen. Should I be showing my presentation on my screen?
I apologize. Let's just make sure that we have things going. How about I go ahead and just...
There we go.
It looks like I should have just given you access to switch your screen.
Okay.
So feel free to try and switch the screen.
That looks much better. Okay.
Perfect.
Yeah.
Okay, go ahead.
Now I'm seeing my slides. Perfect. Thank you so much. Welcome. So let's talk about one of my favorite topics, the internal audit. Just want Hi, can you hear me? I'm sorry about that. Just wanted to. Okay, got it. Just wanted to share a little comic here.
Pamela, I'm not sure why, but you keep cutting out.
Okay. All right. It says I'm unmuted, and for some reason it keeps muting me again. All right, so I should be able to move forward with the screens here.
There you go.
There we go. So let's wanted to share a little comic that I used back in the day. I used to hide in parking lots watching staff to ensure they were following opening procedures of a bank back in the 90s. So I can kind of relate to this one. It looks like we're going to parachute in and do a surprise audit, but I want to keep the whole thing low key. So I thought this was kind of fun. I wanted to share this with you all. And let's move on. Here's the agenda of what I'm going to be covering. We're going to talk about why internal audit, talk about requirements and structure, talk about risk assessment, the life of an internal audit, and talk a little bit about the process, the audit plan, and then I'm going to talk a little bit about the Institute of Internal Auditors, otherwise known as IIA. So before we get started on the different functions and definitions of internal audit, I found out something interesting. Historians have traced the roots of internal auditing to centuries BC as merchants were verifying receipts for grain brought to market. The real growth in the profession occurred in the 19th and 20th centuries with the expansion of corporate business. So I just thought that was kind of fun to say that this internal auditing field has been around for quite some time. So let's just look at some basics here. So basics of internal audit. Internal auditing is an independent, objective assurance and consulting activity designed to add value and improve an organization's operations. Professionals called internal auditors are employed by the organizations to perform the internal auditing activity. And then there's risk. I'm going to go into some detail on risk, but it's the possibility of an event occurring that will have an impact on the achievement of objectives. Risk is measured in terms of impact and likelihood. So there's various types of risk. There's strategic risk, there's compliance risk, there's operational risk, there's financial risk, reputational risk. I'm going to go through some of these in a little more detail, but strategic risk is when a business plan becomes less effective. Maybe this is due to changes in the industry, increases in cost, or technology advances, and the struggles to reach a goal as a result. Compliance risk simply is just identifying and ensuring compliance with all the applicable federal, state, municipal statutes and regulations. Operational risk occurs when there's a failure in the company's day-to-day operations, which could be a people failure or a process failure. Financial risk occurs when there's extra cost or lost revenue, which could be sudden or happen over time. Reputational risk can occur if there's damage to the company's image or reputation occurs. And then there's control. So control is the process of assuring achievement of objectives in operational effectiveness, financial reporting, and compliance with laws and regulations and policies. Control helps us manage the risks within the risk tolerance established by the organization. Hopefully one exercise your financial institution has done is to do the risk tolerance, kind of the risk appetite with senior management, so you have that available to you. So why do you have an internal audit function? Well, it's a CFPB requirement. That's the first answer. So the Consumer Financial Protection Bureau requires us to have a independent compliance audit function as part of the 4 interdependent control components. So board and management oversight, compliance program, and the response to consumer complaints, as well as an independent compliance audit function. There's also a requirement for internal audit by our agencies. So I have added a little slide here to kind of talk about Fannie Mae's requirements, because I thought this was interesting to show you that, these are their minimums. These are the minimum requirements that Fannie is looking for. So to go through these briefly, independence from production of the loan manufacturing process is the first one. Reporting lines being free from internal influences and conflicts of interest. Reporting lines not shared with functional areas of review. And then the next one is reporting lines. Did I say reporting lines? Because again, they're mentioning reporting lines must be to senior management or the board of directors. And then lastly, procedures must be able to assist the seller servicer accomplish its objectives. They are looking for clear, concise approach to evaluate and improve effectiveness of risk management, controls, and governance. Isn't that kind of what we all hope to achieve? We want to identify the issues, reduce risk, ensure controls and in place, and ensure controls are in place, and monitor. Internal audit essentially identifies risks and internal controls to assist in meeting operational goals. And sometimes I think it's fun to share that with senior management because I think they forget why internal audit is so important. We help in our role to actually meet objectives and our goals, and then that helps meet strategic plans to ensure that we're meeting the vision and values and ultimately our company mission. So I think that's just important to remember kind of why we have internal audit. So let's talk in detail kind of the life of an internal audit. And I always like to start off with a risk assessment. It's really important that you have a complete risk assessment for your organization, as this will help identify the risks and aids to prioritize the audits and help develop your audit schedule. Your audit schedule is typically done annually. Sometimes there's going to be audits that you're going to do more often than annually, but you want to have your audit schedule include the time frame in which the audits will be completed, when responses are requested, received, and when the audit is ultimately closed. And again, the next step would be to create an audit plan. So we would need to know kind of what your plan is. How are you going to perform that audit for that particular area? What is the scope of this audit? Is it small in nature, or is it encompassing a review of all of operations? You want to carefully identify the areas you wish to review and test, and then recommend that this is included with interviews with staff as well. This way, you can see if the process documented in policies and procedures is actually what's being performed. Another good source is the CFPB Supervisory Exam Manual. It's a great tool for regulatory reviews as it spells out what the CFPB will be reviewing when they come to visit, if they do, in those same areas. Nextly, you're going to perform the audits. So you're going to perform your audits, you're going to execute your audit plan. It's always good to schedule time with the key players as needed to ensure that you'll be able to meet with those parties as necessary and have them available to you. So then you're going to gather all the audit findings and you're going to create the audit report. This would include documenting your scope, your findings, observations, and recommendations. Once the report is completed, recommend that there is a meeting scheduled with the department or committee necessary to review the findings prior to finalizing the report. I've seen this helps to allow questions to be remedied prior to actually finalizing that report and being able to request the corrective action. So once the corrective action or once the report is final, a corrective action and remediation plan is then requested from management. This can be a struggle for some internal auditors. I'm hoping not all, but it's definitely getting that response can sometimes be difficult. So I recommend that a tight time frame is set to obtain this so it can be closed out quickly and you can move on to the next audit. Lastly, it's important that you retest annually or periodically as needed. As you do an audit, you find that there's a critical failure was found, testing should be done much sooner than annually. So I want to spend a little bit of time on the corrective action, the remediation piece. So it's important you are doing an exit meeting with the department managers. It's important to remember you're part of the same team. You are independent. You work independently of them. However, this actually can make things go much smoothly if you do remember you're all working toward the same objectives. Let's see. As far as the dotted line, it's typical to have a dotted line to the executive team, as an internal audit cannot be influenced by the departmental managers that it's being audited. But I have seen that a dotted line to executive management is really important, as it does also, you want to make sure that you have accessibility, because the accessibility is one way to make sure that you can implement changes and ensure that proper controls are in place. So some of the resources that I have found have been extremely helpful, with the Institute of Internal Auditors being the biggest one. The IIA is a great resource for your internal audit department. They offer certifications where you can actually get additional letters after your name, free monthly webinars on internal audit topics, network opportunities, and guidance on various audit topics. I recently attended one of their social gatherings. It was a great place to exchange business practices and ideas for challenges that arise in this area. They are an international organization. They started back in 1941. They have 70,000 members in the United States, and I think it's important that you find a local chapter. It's a great area that you can improve your internal audit program with that additional resource. The guidances that are out there, sometimes they're on certain topics, and they may be areas that you're actually going to audit in the future. So that's the end, and it's time for David. Thank you so much.
Perfect. I'm going to go ahead and just leave this up a moment in case anyone would like to jot down Pamela's contact information. This will help you to, if you have any further questions about what she's talked about. And we'll go ahead and switch over to David.
Hello, good morning. Thank you, Sarah. And thank you, Susan, who's on the call, and California MBA for having myself and Plaza Home Mortgage presenting some more information or continued information on CMBA, compliance, internal functions, and your CMS. So, as mentioned in my bio, of course, I like to share that I have puppies because they are a joy to play with, but also they are just as fun as being an auditor. Being an auditor now for the last 2 years has been a great experience for myself and learning more about the industry. Loan servicing has been part of my life for a long time, but this has been probably the best 2 years of working as an internal auditor. So the main goal of establishing and reviewing and providing as far as an internal auditor is really what keeps me going. So let's get into our slideshow. So on behalf of Plaza Home Mortgage, let's keep it going with our internal audit, compliance management, and CMS, also known as Compliance Management System. So our agenda, for my agenda today, I got the Compliance Management System, lines of defense, and internal audit risk assessment, continued on from the life of an internal audit. So CMS, what is CMS, Compliance Management System? So financial institutions operate in a dynamic environment, industry consolidation, convergence of financial services, emerging technology, and market globalization. So in order for a business strategy would be to remain profitable, right? In such environments, financial institutions continuously assess and modify their products and service offerings and operations to make sure that we're in line to be a profitable industry. So all these forces combine to create an inherent risk, though, which has been mentioned by Pamela. So to address risk, financial institution must develop and maintain a sound CMS or compliance management system. So this would be integrated into the overall risk management strategy of any institution. So up here on the board, we have knowledgeable and experienced compliance management team, documented policy and procedures. Policies should be established that include goals, objectives, anything that would be outlined for an associate as far as like a procedure that for meeting these goals and objectives, and those procedures should provide personnel with the information needed to perform a business transaction. Educating and training should receive timely, specific, comprehensive training in laws and regulations, and also on the policy and procedures that directly affect their jobs and how they complete their business on a day-to-day basis. Monitoring and corrective actions, as Pamela mentioned, monitoring is key. Proactive approach by the institution to identify procedural or training weaknesses in an effort to preclude regulatory violations. Consumer complaint response, effective communication, board and management oversight. So why is compliance management system important? Maintaining legal compliance, self-identify consumer compliance issues, initiate corrective actions, manage relationships with service providers, effective change management processes. So well-structured CMS will include 3 lines of defense, which brings us to the next topic of the agenda, against regulatory action. So 3 lines of defense: board and management oversight, compliance program, and compliance audit. So the 3 lines of defense model is important, part of an organizational risk management control. It benefits from being simple, easy to communicate, easy to understand. It describes the respective roles of the board and governing body, senior and operational management, risk and compliance functions, and us, internal auditing. It helps avoid confusion, gaps, overlaps that when they assign responsibilities for risk management and control activities, and also highlights the influence of external audits and regulatories. So to ensure effectiveness of an organization's risk management framework, we use this model, the 3 lines of defense, to help understand and organize the various activities and responsibilities that make up risk management and control. As Pamela mentioned, the 3 lines of defense model has been valued around over 20 years, and I know this has been used in the UK for the IIA, so that would be something of, as Pamela mentioned, the IIA has been around for a number of years. So most organizations can benefit from adopting the principles within the model. So the Board of Management Oversight, the Board of Financial Institution is ultimately responsible for developing and administering a CMS that ensures compliance with federal consumer protection laws and regulations. So demonstrating clear expectations about compliance, allocating resources commensurate with the level of complexity of organization, appointing a compliance officer with authority and accountability. Compliance program. A sound compliance program is essential to the efficient and successful operation of the institution, much as a business plan. You will need a formal written compliance program. As we mentioned, policy, procedures, and trainings. The monitoring is key, and consumer complaint response. And then you get down to the compliance audit. So every institution should have monitoring and or audit functions that are appropriate for their size, complexity, and risk profile. Each function plays an important but different role in supporting a strong CMS. So conducting periodic compliance audits, as we say, providing for recurrent reports by the compliance officer to the board. So the model describes certain valuable approaches and important safeguards that can be used to maximize the effectiveness of governance, including the contribution from internal audit. So looking at our 3 lines of defense model. So under your first line of defense, we have the employees of the financial institution. So you have your management controls, internal control measures. So these are the creation of selling products and services or operational supporting customers and products and services. So that would be under your first line of defense, directed up to the senior management. The second line of defense are responsible for providing guidance and oversight of the first line of defense. They are responsible for proactively testing and monitoring high-risk areas to ensure policy, procedures, training, and processes implemented by the first line are working as intended. They're also responsible for fostering relationships between the first and the third, and providing some reporting to the board and or senior management. So you have financial control, security, risk management, quality, inspection, compliance. And then we go to the third line of defense, which is us, which is internal audit. We will independently evaluate the risks, the compliance risks and controls. They are also responsible for reporting to the board and senior management oversight functions. So off to the right, there is external audits and also regulatory. So those, when you have your 3 lines of defense model set with the first, second, and third, anytime you get an external audit, this will provide additional level of independent assurance for stakeholders. So when we get an external audit, this helps us control those external audits in a better sense of what's been presented to us. Regulators apply and monitor rules designed to increase transparency and accountability in a number of areas. So if only one line of defense is working well, it can present risk to the other lines as well as to the institution. It's clear that many institutions are still working towards building 3 strong lines of defense in their CMS, but using this model can help and prevent anything that would, anything that wouldn't be working well. The best compliance management systems evolve to accommodate changing risk factors and exposure. As you work to improve yours, keep in mind it will probably need to change over time, and consider how much change is managed when creating your 3 lines of defense model. So Pamela mentioned earlier about touched on this earlier in the life of internal audit risk assessment. So this is definitely a key function when you're reviewing for your internal audit. Assessments typically analyze the risk inherent in a given business line or process, the mitigating controls, processes, and the resulting residual risk exposure to the institution. Sorry, my screen was blocked. Assessments should be well documented and dynamic, reflecting changes to the system of internal controls, infrastructure, work processes, and new or changed business lines or laws and regulations. Assessments should consider thematic control issues, risk tolerance, and governance within the institution. Assessments may be qualitative or quantitative and include factors such as impact or likelihood of an event occurring. And a high-level summary of a risk assessment results should be provided to an audit committee and include the most significant risk factors facing the institution, as well as how those risks have been addressed in the audit plan. So risk assessment is crucial. It creates an awareness for the internal and external risks that could impact the organization's ability, and it really aids in developing a roadmap and process for the establishment of internal controls to mitigate or minimize the risk to an acceptable level. Next slide, there we go. So as we have here, risk category, I just put down a few: reputation, strategic, operational. There's also financial reporting, data, cybersecurity, compliance. Then you look down at the risk itself. The next step is evaluate and prioritize the risk. When evaluating key risks, you have to ask, why does this risk exist? What is the likelihood of the event occurring? What is the impact if it will occur? So those are things you have to kind of, when you're going through an audit and you're looking at variables that you have to look at as far as your risk assessment. So governance, legal, regulatory, fraud, systems, MIS, people. So the process of risk prioritization ensues using the results of the assessment. And then your causes, your impact, your risk causes or impacts. So ranking these, management can deploy the resources needed to manage or mitigate high probability, high consequence risk events. So not being aligned with the company's structure or risk profile, inadequate staffing or skill set or succession planning, maybe it's dealing with training, or your day-to-day operations. So fundamentals equals pathways to success. So really what you want to do is identify all institutions' business, product lines, services, and functions. As Pam said, you put yourself together into an audit plan for the year, identify activities and compliance issues within those businesses, product lines, services, and functions that should be audited. Could be more than once in a year. Include profiles of significant business units, departments, and products that identify businesses and control risks. And document the structure of the risk management internal controls. Sometimes people make flow charts, which can help to learn more about for your industry. You can make a flow chart that would help. Include board or audit committee approval of risk assessments or the aggregate result thereof, an annual risk-based audit plan. Implement the audit plan through planning, execution, reporting, and follow-up. Have systems that monitor risk assessments regularly and update them at least annually for all significant business units, departments, and/or products. And use a measurement or scoring system to rank and evaluate business and control risk of significant business units, departments, and products. So this would be going into the scoring system that we use or that can be used. is you want to rate your risk assessment based on the information that you have, whether it be through interviews, notes, anything received from the stakeholder or person of authority within the department. So when you go into your risk assessment, you want to give it a certain finding or a category that would gauge the risk assessment of a minor would be your lowest, or acceptable would be okay, but of course, minor would be your lowest risk. If any weaknesses are minor in nature and would have minimal impact on compliance, work performance, or reputation. Moderate, there are no major or critical findings, but performance is less than satisfactory and may lead to operational delays or potential damage to reputation. Major, these are serious deficiencies that result in unsatisfactory performance. These are deficiencies or weaknesses that may result in penalty, major operational disruptions, and of course, as we mentioned, reputational damage if not addressed or resolved by management or the board of directors. And critical, these are the more severe, the high risk. Performance is critically deficient, leading to extremely unsafe and unsound practices or conditions. The volume and severity of the problems are beyond the management's ability or willingness to control or correct. This would require the senior management board to intervene and to determine the next steps to relieve the critical status of these findings. So ensure the most critical risks facing the company are identified and incorporated into the audit plan. On your report, the results in the performance of the targeted audits, horizontal audits, and special products should all have something of sort that would kind of rate the risk assessment on each particular category. Internal audit must provide an independent view of risk, but that view can and should be formed in a collaboration with management, as mentioned also by Pamela. That's all I have today, but of course, as I always get the notion, just as Pamela said, we have keep smiling. Maybe the auditor will forget about the report she asked you for yesterday, but I never forget, so we'll make sure we get on you. But sometimes it happens. That's all I have today, Sarah.
Perfect. I will go ahead and also skip to the next slide there to share your contact information in case anybody has any questions or follow-up. And I do appreciate both of your little humor slides. I do think those were super fun. Kind of adds a little humor to the topic. And then we will take some questions. If anybody has them, go ahead and put them down in your, to the right-hand side, your questions dialogue, and I will be happy to share them. It does look like we have one question of, will this presentation be shared? And yes, it will. It will take us a couple of days to get it out again, but it has been recorded and will be shared back with you. And so far, that's the only question that I have. So we'll go ahead and skip on to our next webinar. And Monica, do you have any notes or tidbits or things to say to close us out for this webinar? And looks like she may not be available. So I'd like to thank you on behalf of the California MBA for joining us today. If you do have any questions, I'll stick around for just a moment. And if I cannot answer them, I will certainly get those to David and Pamela. So thank you both, and thank you to all of our presenters today. Thank you and have a great week.